Good evening, friends. Whether third parties can be made signatory in arbitration, we had received a lot of messages on that, and we thought that if somebody who is well versed and who can explain this topic of late, which has caught up the legal minds and otherwise also, we had requested Mr. Hiroo Advani, founder and chairman Advani Law, who is himself an authority on international and domestic arbitration law. He happily agreed, and the fact that such a topic could be explained by a person who we can say is a legal luminary or is an institution within himself. We are obliged on behalf of Beyond Law CLC as well as the viewers who are watching us live on the YouTube and on this platform to serve Mr. Hiroo Advani to accept our invite. Over to you, sir, and thank you for accepting our invite.
Thank you very much, Vikas. Let me just do a slight correction. It was my mistake in the title. It's not can third parties be made signatories to the arbitration, but it's can third parties be made parties to the arbitration. It would be interesting to start where India has come in arbitration and where we are moving forward and where we started from. Originally, one of the most worst features of our arbitration was many of the arbitration clauses would contain a clause whereby one of the parties, usually being a governed party, would appoint their own arbitrators, sometimes their chairman and managing director, or sometimes he could nominate one of his employees or anybody close to him. Fortunately, after our amendments in the Arbitration Act, the Supreme Court took a very strong view in their judgment of Perkins and said this is no longer acceptable, and a party cannot appoint its own arbitrator to dominate the proceedings. This was a major step forward. Then going on from there, the earliest case of making non-signatories in arbitration took place in France, where Dow Chemicals Zurich and Dow Chemicals Europe were signatories to an arbitration agreement with Saint-Gobain. And as we know that it's settled law that the arbitration agreement itself is a separate agreement from the remaining part of the agreement. In this case, Dow Chemicals USA and Dow Chemicals France, which were not signatories to the agreement, commenced the arbitration. And the arbitrators took the view that as Dow Chemicals USA was the parent company of all these companies, and as Dow Chemicals France had actually done a lot of the work in the arbitration, that even though they were not signatories to the arbitration agreement, they could certainly be parties to the arbitration and commence the arbitration. They successfully succeeded in it and carried on. This then was again tested in England in the earlier case of Peterson Farm. What Peterson Farm was doing was producing, selling chickens, grandfather chickens, to another company, and that other company was going to breed chickens and give it to its various subsidiaries in various parts of England. Those original chickens, grandfather chickens that were sold, were found to be infected and contaminated. So obviously the chickens that they produced were not usable in the market, and they could not give them to their subsidiaries, or they could not in any way use them. The arbitrators, using the example of Dow Chemicals, accepted that and they passed an award. The English courts took a very different view. They said this is not going to be possible because the whole idea of having a separate company was that each company could protect itself, and it was completely ring-fenced. So that if they had not signed the arbitration agreement, they could have no liability for the same. This was tested in various courts in England, And the classical case was of a Lebanese company, Al-Butam, which gave a franchise to some parties to run restaurants under their name all over England with separate agreements, separate arbitration clauses, and they would pay them dues. Ultimately, the Lebanese company reorganized itself and called itself Coutts. But Coutts were never made a party to the arbitration agreements. Although they carried on the business for a while, they were not a party to the arbitration agreement. So when they commenced the arbitration, based on this Peterson decision, although they had the franchises were running, successfully making money, they said no arbitration was maintainable because Coutts itself, after reorganization, had never signed the arbitration agreement. So England has consistently taken this view that you cannot have each party, if the separate company is completely ring-fenced and cannot be made parties to the agreement. This was confirmed in a case called Dalla, where again this happened in France, and the French Court of Cassation, which is the equivalent of our Supreme Court, accepted that the government of Pakistan was liable because they had built these small shelters in Saudi Arabia which had failed, and so they were all liable to be paid. The problem is the agreement, although the court, which was considering whether it was a valid award or not, was the French Court of Cassation upheld it. When it sought to be enforced in England, the English courts took a completely different view, saying the government of Pakistan was not a party to the arbitration. It had some other company that was there which had been dissolved, and therefore there could be no liability. So there has been this consistent view of different countries, particularly in Europe, taking different views of whether third parties can be party to an arbitration or not. In India, our earliest case here was Chloro Control. Chloro Control, don't forget, was an international arbitration. There were a number of subsidiaries of Chloro Control, one of which held a patent, one of which was doing the work, the other was providing another service. So the Indian courts took a view that under Section 45 of the Arbitration Act, as they use the words claiming through or under, all the companies could be made a party to the arbitration. And so Chloro Control was the first case in India that took the view that despite what the English courts have taken, that they would allow non-signatories to be a party to the arbitration, but only in international arbitration. Subsequently, the Indian Act was also amended. Section 8 was also amended to include the words claiming through or under. And therefore, even for domestic arbitrations, non-signatories could be a party to the arbitration. Now, the theory of making them non-signatories a party to the arbitration is a variety of theories. One is the concept of piercing the corporate veil. That if one company is a signatory, but another company is assisting in the actual work to be done, then you pierce the corporate veil and make the non-signatory a party to the arbitration. The other theory is one of agency, that one is the agent of the other, and therefore they can make you can pierce the corporate veil. A third theory is of what they call economic reality. The economic reality is that if it's really like one entity, then why can't the parent company be dissolved? Because don't forget, in many cases, particularly when their business is done in India, a smaller company of a big company, parent company sitting in US or France or wherever, is a subsidiary and does these very large contracts. And when they do the very large contract, they're probably getting supplies from other countries, they're using patents from other countries, they're getting manpower from other countries, they're getting technology from other countries. So it's really a group effort that is actually carrying out the thing. But if there's a dispute and you sue the Indian company, Sometimes the Indian company is a relatively small company, only consisting of a few lakhs or few crores of rupees, and cannot withstand an arbitration which several times runs into hundreds of millions of dollars. Because when projects of that size fail, they're very large projects, sometimes they have to be scrapped, or sometimes there's a claim that there's a fraud on the patent, or the patent really belongs to some other company. For whatever reason, if those projects fail, they run into hundreds of millions of dollars, and quite often the Indian subsidiary can't withstand that. So CLA control has now been consistently followed in India, despite the fact that normally India, being a common law country, has followed decisions of the English House of Lords or the English Supreme Court. They've taken a very strong view on this and made non-signatories a party. In fact, in one very strong case, they even permitted, although this party was not a party to the arbitration, but during the time of arbitration, the defendant company sold off its assets to another company. And in this case of Cherin, they allowed enforcement against a company that had bought the assets, despite the fact that it was not even a party to the arbitration. It had not participated in the arbitration or anything. But although those assets had been sold off with a view to defeat the award as and when it came, the Indian Supreme Court upheld it and said, yes, in certain circumstances, it can be forced, and even it can be enforced against a non-signatory to the arbitration. So India has taken a very different view. The Singapore courts have followed the English view and taken the traditional view that each company, the whole idea of having a company is it should be completely ring-fenced, and therefore no other companies which are not signatories to the arbitration cannot participate in the arbitration, cannot be dragged into the arbitration, cannot commence arbitration, etc. So this is where India has taken a very bold view. But more recently, there was a judgment before the Supreme Court, and Justice Ramana, just before he retired, and Justice Bopanna took a view that, look, we have a doubt on this theory, we don't agree with it at all. And the reason, they said, look, there's no legal justification for this. It's all very well, there's an economic justification that the parent company should also be liable for this whole thing, but there's no legal justification for it. And so this matter went into a 5-judge bench, which we argued. And we argued that, look, for 10 years, the law in India has been consistent that non-signatories can, in circumstances, be a party to the arbitration. And it's not a question of economic realities. There's a legal justification in either piercing the corporate veil, estoppel, and different legal theories for different cases, agency, which can make non-signatories a party to the arbitration, and it's just not economic necessity. In fact, Justice Suryakant, who was sitting in the same bench, explained the whole thing very well, and he took a completely contrary view to the Chief Justice and said, no, this theory has been established in India. There is no point in upsetting the arbitration in this whole arbitration system in this manner. And yes, I can understand that the courts want to review if we are doing and introducing non-signatories very, very broadly. Maybe there's a time to make a narrower test as to when non-signatories can be done, but this theory cannot be done away. So unfortunately, this has been heard by a 5-judge bench in March. And although the Supreme Court in India normally and has repeatedly pulled up the other high courts that you must give your decisions within 6 months, you cannot keep them pending. And this decision has been kept pending. But there's a reason behind that, there's a logical reason behind that. Because there was that very unpopular decision in the Supreme Court where they say if the agreement has not been properly stamped, then you cannot proceed for arbitration. That agreement has been impounded and go for stamping, etc. Arbitration can't commence. There has been a lot of unhappiness with that judgment, and that has also gone to 5-judge bench. After arguments, although the Supreme Court expressed a view, and quite a strong view, that they think that judgment is wrong, as well as in our judgment, they think that it's wrong, that there should be non-signatories should be a party to the arbitration. Repeatedly, the government counsel on the other side, the Attorney General, Solicitor General, Additional Solicitor General, have been telling the courts, please don't pass any orders. We are going to review the Arbitration Act. It's now been 9 or 10 months, and there's been no review of the Arbitration Act in any manner whatsoever. Yes, there have been committees, there have been suggestions, a number of us were asked to write suggestions for the amendment. The amendment will also bring into being the institutional arbitration, because I don't know if some of you read the speech, the Vice President yesterday said, the entire arbitration process is in the grip of retired judges, and that should change. The idea of change was to bring in institutional arbitration, where others, apart from retired judges who are qualified in the arbitration field, could be appointed as arbitrators, etc. But unfortunately, we've seen the winter session of Parliament does not have an arbitration bill on its, so we don't know when it will happen. There's no uncertainty when it will happen. And the Supreme Court, unfortunately, has held up its hand and not passing judgments in any of these five-judge bench arbitration matters, because they keep feeling the Arbitration Act will be amended and will take care of some of the anomalies so that we can all move forward. Unfortunately, this has not happened. In the US, they've taken a different theory. While they accept the English theory that each company is a separate entity and therefore should have separate protections if they're not party to the agreement, they use the theory of promissory estoppel. That if you have acted in a manner that you are party to the arbitration, then in those circumstances, they will make non-signatories that were party to the arbitration on the ground of promissory estoppel. But they haven't come out very strongly. Their theory is limited only to promissory estoppel. It is not limited to economic realities of subsidiaries and parent companies becoming party or piercing the corporate veil, etc. They've worked on a very, very limited theory. The Canadian court has now looked at the New York Convention, and having looked at the New York Convention, they say that New York Convention is very clear that arbitration awards must be enforced in reality, and whatever steps are required to be taken to enforcement should be done. So the Canadian courts have taken a view, and now we will accept non-signatories to our arbitration on the New York Convention. They overturned their old law and accepted the new principle of non-signatories will now be a party to the arbitration. Unfortunately, there's a division in the whole world as to which is right and which is wrong. And so for success of your arbitration, particularly in the international sphere, it depends first and foremost which law you choose. You choose Indian law, and certainly non-signatories can be made party to the arbitration. If you choose English law, it can't be done. Now, if you step back, the bigger worry is, okay, if you choose Indian law, that's fine, it can be done. But if you go for enforcement, in certain countries, it will be against their public policy. So, although you have succeeded in your court, you won, say, an India-seated foreign arbitration, it's gone up in challenge to the Supreme Court accepts it, then you go for enforcement. If you go for enforcement in France, no problem. If you go for enforcement in England, you have a major problem. If you have to go for an enforcement in Canada, no problem. If you go for enforcement in US, maybe not, depending on whether there's a promissory estoppel involved. or otherwise they told me you can't enforce in Canada. In Europe, you can enforce usually in France, Belgium, and more of the civil law countries are permitting enforcement. But this is a real problem which in fact requires a global situation. It should not be that this is a law in one country and enforceable, everything is done as per the law, and another country becomes against public policy. Because there they accept that each company is ring-fenced and a separate entity, and then it cannot be done. This is really a problem that, of course, the Indian courts have to tackle it. So Indian Supreme Court can tackle it on the Indian basis. But we're all waiting for the judgment. Now 8-9 months have gone and no judgment. Whether the act will be amended, when it will be amended, we don't know. So presently, if you were to go to the Supreme Court and make and because for international arbitration, the Supreme Court appoints the arbitrators. You go there and say, I want non-signatories to do. Some benches are saying, let's wait for the decision of the court. Some benches are saying, no, we'll follow the old law. It has not yet been changed. And although the bench of Justice Ramana and Justice Bopanna said we have certain doubts on this, it was a 3-judge bench, so they could not overrule another 3-judge bench. In any case, one of the judges, Cant, was against it. So some courts are saying, let's wait for the judgment. Some courts are saying, we won't wait for the judgment, we'll appoint the arbitrator. So in the Supreme Court, there's something of a mess. For even the appointment of an arbitrator now starting to take 1 year, 1.5 years. So this is something of a quandary which our Supreme Court should be looking at closely to solve the issue as quickly as possible. What is the answer globally? Nobody knows, because each country is taking its own view, and particularly on the issue of public policy. If it's Indian law and it's permitted under Indian law, and if I'm enforcing it in London, then surely Indian law, if it's not against Indian law, public policy, Indian public policy, the English court should accept this is not against public policy because it's enforced in India. But once again, courts in England or Singapore are starting to take a different view that although it is under Indian law, it is against their law, and in a matter of principle, because the company should be ring-fenced, so enforcement becomes a problem. So this is one of the issues that is going to require a long-term global solution, which we hope that will come in good time. But it seems to be taking too long, and we don't know when this will be done. With that, gentlemen, I'm quite happy. If you have any questions, to answer some of them through the moderator, or I'm happy this is the presentation that I wanted to make, which is a quandary that a lot of us who are doing international arbitration are facing on a day-to-day basis. Thank you very much. Vikas, if there are any questions that you can see, I'm happy to answer any questions. If we have no questions, thank you to the host and thank you to the audience. Thank you very much and have a pleasant Sunday evening. Yes. I'm back. Vikas, can you hear me?
We can start off.
Hello? Yeah, if there are any questions, I finished. If there are any questions, I'm happy to answer.
No, thank you, sir. Thank you.
If there are any questions, I'm happy to answer them now. Vikas, Smita Sehgal wants to be unmuted.
Good evening, sir. Thank you very much for this informative session. I have one very short question, so I'll make it very crisp. There is an ongoing arbitration which has been filed against an Indian subsidiary of a Turkish company. Now, this party is in liquidation. But before he went to liquidation, when the arbitration commenced, we had filed an application for impleadment of his Turkish parent. So the party with whom we have contract with is already in arbitration with us. We have filed an application for impleading his parent company for certain very good reasons and some good documentation also. Now, subsequently, this company has gone in liquidation, and the arbitrator has put the proceedings in sine. In these circumstances, is there any method by which we can revive or commence the arbitration against the foreign parent company, the Turkish company?
Is the arbitration seated in India?
Arbitration is seated in India.
Yes, certainly. You can go to the court immediately and ask them to be joined as a party, because the law in India as it stands is that non-signatories can be made a party. So if the Turkish company, the parent company, had actually participated in the activities or been part of the negotiations or in some way was involved,
Yes.
the Indian courts have a right to make him a party, and you can carry on the arbitration before against a parent company and conclude it in India.
Okay. Thank you, sir. Thank you.